first case is in Re Southeastern Eye Center, and we will hear from the appellant.
To please the court, Chief Justice Newby, associate members of the Supreme Court. I'm here today because of clear violations by the receiver in this case. Mr. Fields, on behalf of the receiver, says that this is a simple contract case. It's a contract case, all right? It's a contract case of the law of the land. We are all obligated to follow the law. The receiver, through Mr. Fields, refused to pay the IRS, with the IRS obviously being a priority creditor. No law allows, none that can be found, that allows for a receiver to pay unsecured creditors ahead of secured creditors or ahead of priority creditors. Clearly, what Mr. Fields and Mr. Juder did is that they went out of order. The Sharp case from 1952 was brilliantly written. It took a very complex process and put it into something that was easily understood, guidelines that were easily followed, could be easily followed. It said simply, number one, secured creditors are to be paid first and in full. Second, taxes are to be paid as priority creditors second. And third, and only after the secured creditors have been satisfied, the priority creditors have been satisfied, can unsecured creditors be paid.
Mr. McDaniel, do we have jurisdiction here? Isn't this another appeal from an interlocutory order?
No, this is a final order from the court. Judge Bledsoe said, rejected that they should recompense myself and my wife for the taxes that we paid that they should have paid. And he made it as his final order.
Is the action still ongoing?
There's no action against me ongoing. The one last thing that they had was I was a guarantor on a mortgage that was fully paid as of September the 24th, 2012. They took that case to the clerk of court in Guilford County where they were summarily dismissed. There's nothing out there right now that has anything to do with me. The order regarding the taxes and whether or not I should be recompensed for having had to pay what they should have paid is a final order of the court, and there's nothing right now in front of the North Carolina Business Court, and this receivership has anything else to do with me.
And if I might follow up, I anticipate that your friends on the other side are going to talk about a release. And did you sign a release regarding the obligations of this organization when you exited this situation? Did you sign that release? I
signed an agreement. My wife and I signed an agreement. We voluntarily surrendered $850,000 worth of stock, and that $850,000 was used by them. In the agreement, and in the agreement that they made with EBSCO, all of the bills of Southeastern Eye Center and all of its groups were to be paid. I think my wife and I had the right to believe that they would follow the law. I don't think there's anything in there, there's nothing in the release agreement that says that they can break the law. There's nothing in the agreement that says, oh, they can decide not to pay a certain creditor. There's nothing in the agreement that says that they can violate the Sharp case. There's nothing in the agreement, the release agreement. This is something they did after we signed the release, not before, after. They did not pay the IRS. Mr. Fields told the IRS they didn't have the funds to pay them. At the same exact time, they were paying their own unsecured business partner creditor, for which they have a commission fee split deal, monies more than was owed to the IRS at the same time. We signed a release at a date certain. Their actions took place after that release had been signed, not before.
Well, and if I might follow up, at least the brief of the appellees talk about that release, and I didn't see anything in your response to that, dealing with that, other than the point you're making about the general law, but not specifically dealing with this, this release. You did not dispute that in the briefing, and so I share some of the concerns that my colleague has here. Since you didn't address that, or at least I didn't see that you addressed it in your brief, how is that before us when you're really arguing something that's different than what at least I perceive may be in front of us today?
I think there's a reasonable expectation, Justice Behringer, to expect that anyone you make a contractual deal with in regard to anything, that they're not going to be able to exercise anything outside the bounds of the law. The law is something we all are obligated to follow. They didn't do that. Now, I'm not arguing about my contract. I'm arguing that what they did was, when they stiffed the IRS came to me. There's one huge difference between me and what Mr. Fields did. Mr. Fields told the IRS something that he knew was absolutely, utterly untrue. He told them that they didn't have the funds to pay them. He told the court that they would pay them first thing. He didn't pay them at all. He told the IRS something that was false. When the IRS came to me and asked for the money because he wouldn't pay them, the difference between me and Mr. Fields, I didn't tell him I didn't have the funds. I went ahead and wrote him a check, because none of us have the right to violate federal law. None of us. And that's the point here. I think this is a violation of the contract that we're all involved with. As human beings, as citizens, you expect whatever agreement you make with whomever you make, that they're going to follow the law. And they clearly didn't do that.
And so before we finish, and I'll let you get back to your argument in chief in just a minute, I'm still concerned about the lack of your dealing with the release issue itself. Can you explain to me why that release is not relevant here, other than the argument you've already made? Because you did freely sign the contract that did contain a release in it. And so I'd like to give you the opportunity to explain that, because that's what the other side is, I'm anticipating, and they'll correct me if I'm wrong, but I'm anticipating that they're going to argue.
I think that's a reasonable question, and my statement to you is, I don't think anybody can sign a release from somebody doing something that's unlawful. And what they did was clearly unlawful. Telling the IRS you don't have funds to pay them when you do, that's clearly an unlawful act. I didn't release them from being lawless. I released them from what we knew to be the facts at the time. It didn't say in the agreement, oh, we release you even if you rob our house, even if you come in and take our furniture, even if you come in and steal our car. We didn't say that. We said we release them as of the situation, in anticipation that they, like anybody else, would simply comply with the law. The contract I'm arguing here is the contract we all have, and that's the obligation to follow the law. They didn't, I did. He's benefiting from violating the law. I got hit by complying with the law. There has to be equity in there somewhere. The obligation they have and had to pay this obligation has been on the books since the first year of the Washington administration, 1789. So it's been a long time. Receivers who have failed to pay the IRS in the past have been held to have to pay for it personally. That's how much how important it is as far as the court is concerned. As an example, the United States Supreme Court said in the King case, King versus the United States, we hold that King, being a receiver, on the facts of this case did have such a responsibility. He must have been aware of the government's potential claim. They obviously did because they conversed with him. In these circumstances, we think that King was possessed of a sufficient degree of control over the allocations among creditors of the assets in his possession to give rise to responsibility under Section 192, foreseeing that the government priority was paid. It imposed upon him a duty to see that that was done. This is a duty of the receiver and his attorney to follow the law. They clearly did not do that. It's long-established law that they had an opportunity to pay it. Mr. Fields made commentary to the court that they would pay them first thing. He made the comment to the business court that they didn't have funds to pay them out of a CCSEA account. They made a new EPSCO account. What he basically did is what Mark Twain did when somebody was asking him to loan him money all the time. So he named one of his pockets in the world. And when somebody said, well, can you loan me some money, Mr. Twain? He said, no, I don't have any money in the world. Well, that argument might have lasted or might have helped Mark Twain, but it shouldn't be an argument where they sit there and say an account they know is empty is insufficient of the funds when they had the funds sufficient to pay them and didn't do so. To quote Mr. Fields, he told the business court, and the reality is CCSEA has no funds to pay the Internal Revenue Service. Well, New EPSCO did. When it has funds, they are first in line, and we're looking to get funds for them so they can get paid, but it just hasn't happened yet. Well, it's not going to happen. They have a new account. They're telling us, oh, I don't have an account over here that's zeroed out. Had plenty of money in the account to pay their business partner with whom they have a business split. At the same exact time that Mr. Fields was telling the IRS didn't have the funds, he was paying the funds out that was more than sufficient to pay them. He was just paying them to his business partner, an unsecured creditor. There's nothing short of an appeal that correct the abject failure of the receiver to follow the law and pay the IRS with priority. The failure to do so has caused grievous harm to me and my wife, and there's no remedy but through this court. Even if the business court's decision being appealed only exposed to one branch of the subject matter, not every conceivable subject, the decision would still be final under these circumstances. My concern is that this is one of a plethora of problems that have been caused by this receiver paying creditors out of order. There's still a secured creditor to be paid that's owed over $1 million. They paid them out of order, and they've given preference to their unsecured creditor business partner with whom they have a commission fee split. That seems like self-dealing to me. I would like to reserve the balance of my time for rebuttal if needed. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court. My name is Rob Fields. I'm with Durham County Bar. I represent Mr. Gerald Juder, who is the receiver of a number of entities. We refer to them as the receivership entities. Mr. Juder is here at the table with me today. This is yet another interlocutory appeal from Mr. McDaniel. There are claims that remain against other parties that have not been resolved, and there is continuing work that's going on in this receivership.
And sir, if I might just begin to give you the opportunity to respond to the questions that I had to ask your friend on the other side. My understanding is, and he did say that he did sign a release, can you help us understand what role that release plays in this case?
Yes, there are actually two releases. One is dated September of 2015. The other is dated August of 2015. These releases were part of settlements among a number of parties, including Mr. McDaniels and his wife. In those releases, the receiver gave up all claims against Mr. McDaniel. In particular, he gave up that, in particular relevance to this appeal, the receiver gave up all claims against Mr. McDaniel for breaches of his fiduciary duties in failing to pay these taxes. The Sheriff Garrison LLC case is a good description of the fiduciary duties that CEOs like Mr. McDaniels owe to corporate entities to pay federal payroll taxes and to do it in a timely and appropriate manner and not to expose the companies to liability. Mr. McDaniel's liability for having exposed CCSEA to substantial claims from the Internal Revenue Service was released by the receiver as part of this settlement. In exchange, Mr. McDaniel and his wife released the receivership entities from all claims, known or unknown. The language of the release is very broad. It's hereby release, or the releases is very broad. It's hereby release, acquit, and forever discharge the receivership entities from any and all claims, actions, causes of action, suits, demands, on and on, of whatsoever kind or nature, whether known or unknown, and whether contingent or liquidated, and whether at law or in equity. So they were very broad releases. Mr. McDaniel has never disputed Judge Bledsoe's order, the order that's before the court on this appeal, the March 2023 order. That order specifically finds that Mr. McDaniel did not dispute the release. Mr. McDaniel, in his brief, did not dispute the release, either one of them. He has never raised any issue regarding the releases. He's never addressed the applicability of them, the findings of the trial court regarding the release, the scope, interpretation of the release language, the status of the agreements. He's never addressed any of that with either the trial court or here. He simply ignores the releases. In the case of Koch versus Bell, Lewis and Associates, 176 NCAP 736, that appellant also made no challenge to the release and in essence abandoned any ability to dispute the contents of the release.
Well, and Mr. Fields, I appreciate your citing to that case, but it is a North Carolina Court of Appeals case. Am I correct?
Right. Yes, yes,
So
Your Honor.
that is not, while it might be instructive, it's certainly not dispositive of this case.
Correct.
While I have you interrupted, would you address the argument that he's making that at least, and he can correct me in his rebuttal if I'm getting this incorrect, but what I'm hearing is notwithstanding the release that your client, the receiver, paid these debts out of order, and that is problematic. How should we factor that into this case?
The arguments that he's making in that regard were all addressed by Judge Bledsoe in an August 2019 order that has not been appealed. And literally every argument that's been made in the brief and have been addressed here were directly addressed by Judge Bledsoe with much more clarity and legal acumen than I can muster, but he directly addressed those. There was no appeal of that order, and that order remains the law of the case. He found that Mr. McDaniel isn't the person to complain, isn't the proper person to complain. If the IRS wants to complain, they can complain. The IRS has not complained. He found that there was no duty owed to Mr. McDaniel to pay any particular claim in any particular order. He found that all of the alleged supposed misconduct of the receiver, which we deny, but is simply irrelevant to this issue and irrelevant to this appeal, had nothing to do with regard to these taxes. The penalty that he was assessed, there is a email from the IRS in the supplement. It's supplement page 16, in which the IRS asks, can we amend our claim? What they were trying to do is, what had happened was there's Dr. Matthews, a minority shareholder. They had taken Dr. Matthews' refund, his income tax refund, and applied it to the penalty for the failure to pay some of these payroll taxes. They also took money from Dr. Epps's sale of his house and applied it to some of these penalties for this. Dr. Matthews disputed it. The IRS on appeal reversed and gave him his income tax refund back. And so at that point, the IRS said, can we amend our claim? Has the deadline for claims passed? We said, yes, the deadline for claims has passed. They did not file, as Judge Bledsoe explains in his August 2019 order, the IRS took no further action. They did not ask to file a late filed claim. Instead, they turned and they collected the penalty from Mr. McDaniel. So there's not even a claim from the IRS for the receiver to pay that's in the existing receivership. So under 1-507.7, the 2016 version, which applies to this receivership, under that statute, the receiver has no ability to pay the claim because the claim hasn't been made. So there is no priority. In addition, Mr. McDaniel conflates the funds available in the settlement with Dr. and Mrs. Epps. Money from Mrs. Epps was provided to an entity called Keps Nuco. That is the majority of the money that's available to the receiver. Mrs. Epps had the money. CCSEA was a defunct practice that had gone out of business in 2012 that had been insolvent for a decade. That defunct practice had no money, and it has no money unless we recover money for that entity in a lawsuit that we have going on against Dr. Matthews right now. So there's no money in CCSEA. It's all in Keps Nuco, and Keps Nuco has no liability for any of these taxes.
I'd like to go back to your comments at the beginning of your argument. You said that the order at issue here is an interlocutory order. So what's your position on whether we have jurisdiction? Well, did you argue the issue in your brief? I don't think you
At the very beginning of the brief, we point the issue out. We didn't rehash what's already been addressed 2 other times with this court. We've been here 2 other times. You know, selfishly, I think we'd like to get something decided. Legally, I don't know that you all have jurisdiction, but I think that's your call. I mean, there's our claims pending. There's there's none of the required language in the order that would normally be associated with an interlocutory appeal. Whether this affects a substantial right it's not readily apparent what that substantial right would be. But again, this is our third time here with Mr. McDaniel, and this issue doesn't impact other issues in the receivership the way the earlier appeals did. So there's some distinction, but your concerns are well-founded.
What is the status of the litigation at this point? How much longer will it go on before there is a final judgment?
We have a trial scheduled in August of claims involving a trust that acquired some notes and the status of those notes. We have a foreclosure proceeding that is in process, and then we have a separate lawsuit against Dr. Matthews that probably will be ready for trial in late this year, early next year. So we are grinding towards the end. Most of the creditors and the things that needed to be taken care of were resolved years ago, but there's some lingering litigation that has been hotly contested that has kept this receivership going much longer than Judge Bledsoe wanted it to.
Is there a practical effect of this appeal on the ongoing litigation from the standpoint of does Judge Bledsoe stop everything based on this appeal? Or
He has not stopped everything based on this appeal. The other appeals slowed things down. This appeal is isolated enough that it did not. But the law of interlocutory appeals is what the law of interlocutory appeals is, and you all get to make that. In any event, Dr. Epps paid over $100,000 in tax penalties to the IRS for his role, personal, didn't come out of the receivership. CCSEA has a pending claim for over $200,000 in payroll taxes for its role, that if we recover funds, will be paid. If we don't recover funds, there won't be any funds to pay it with. But if we recover funds, that's the priority claim. There is no injustice in Mr. McDaniel being assessed a penalty of $80,000 for his central role in the failure to pay payroll taxes. These are the taxes that were withheld from employees' paychecks. And his explanation as to why they were not paid was because he paid Dr. Matthews over $900,000 a year. And so instead of paying the Internal Revenue Service, he paid Dr. Matthews because Dr. Matthews complained and said he wouldn't keep working if he wasn't paid his $900,000. We believe that was a breach of his fiduciary duties. We released that breach of his fiduciary duties. In exchange for that release, CCSEA was released. That release should be enforced. That's what Judge Bledsoe did, and we think there is no error that has been shown in Judge Bledsoe's decision to enforce that release, which means none of the other issues that were raised and addressed in the August 2019 order that's not at issue here, none of those issues are properly before the court. And for that reason, we would urge the court to affirm Judge Bledsoe's order and let us get back to the work of finishing up this long-lasting receivership. Thank you.
thank you. Any rebuttal?
Very briefly, I find it interesting that he said that the IRS doesn't have a claim, but he says that if CCSEA gets the money, they'll pay them. I don't know how you can do both. If you don't have a claim, then you don't have a claim. If you do have a claim, you do have a claim. The law is that the IRS doesn't have to make a claim. It's the responsibility of the receiver to find out if there is something owed. They clearly knew it was owed. The release agreements that were signed in 2015 have nothing to do with the misstatements and the untruths told to the IRS in 2017, which visited upon me to pay the $83,000 after we'd paid in $850,000 in the release that was signed previous. I think that I'm really concerned as well about how this is going to affect how other receivers operate. It's clearly established. Sharp case been in law in North Carolina here for 3.5 generations. And it's very, very well written. It's brilliant in its simplicity. It's, somebody asked Albert Einstein to talk about the theory of relativity. Everybody's thinking he was going to go to this long discourse, and he said, well, if you're sitting on the eye of a stove that's on for 1 minute, it seems like an hour. If you're sitting next to a pretty girl for an hour, it seems like a minute. It sort of just made it so that it was kind of the clarity was there. The same thing with the Sharp case. It took something that was just incredibly difficult, and it put together a menu that you need to follow. Secured creditors get paid first, priority creditors get paid second, unsecured creditors get paid third, in like manner. Not identically, but in like manner, so it's all fair. They should have paid the IRS claim. They didn't. They paid their business partner with whom they have a commission split deal. That's what they did with the money that should have gone to the IRS. Thank you for your time and consideration.
Thank you. Mr. Clerk?